Hello friends, in the series on income tax cases, today we will discuss a very important case in which a very pertinent issue and very interesting issue was there before the Honorable Bombay High Court. And the issue was that if the assessing officer is not required to pass the draft assessment order, but he passes the draft assessment order and asks for the objections of the assessee, so whether in that case the assessment can be quashed only because of the reason that the draft assessment order was not required and it was passed. This issue has been taken up by Honorable Bombay High Court in the case of Classic Legends Private Limited versus Assessment Unit and others, and this case is reported in 484 ITR at page number 550, and the date of the judgment is 9th September 2025. In the present case, the assessee is a private limited company. During the assessment proceedings, the assessing officer noticed that there were some international transactions of the assessee, due to which the assessing officer referred the matter of the assessee to the transfer pricing officer under section 92CA, and in response to that, the transfer pricing officer passed his order under section 92CA subsection 3, and there was no variation proposed by the transfer pricing officer. When the assessing officer received this transfer pricing officer order, the assessing officer issued a draft assessment order to the assessee and then passed the final assessment order under section 143, read with section 144C. The assessee challenged this assessment order in the Honorable Bombay High Court on the ground that in the present case the draft assessment order was not required, and the reason for this was that according to section 144C subsection 15 clause B, the assessee is not an eligible assessee. Now the question arises that who is an eligible assessee according to section 144C subsection 15 clause B. According to section 144C subsection 15 clause B, clause I, an eligible assessee is an assessee where the matter of the assessee has been referred to the transfer pricing officer and the transfer pricing officer have recommended some variation in the transfer pricing transactions. And according to section 144C subsection 15 clause B clause II, any foreign company and any non-resident is an eligible assessee. Now, when the matter was heard by the Honorable Bombay High Court, the court said that in the present case there is no doubt that the assessee is not a non-resident, the assessee is not a foreign company. So, the assessee is not an eligible assessee according to section 144C subsection 15 clause B clause II, and since there is no variation proposed by the transfer pricing officer, so the assessee is not also an eligible assessee according to section 144C subsection 15 clause B subclause I. As per contra, the revenue was pleading that when the matter has been referred to the transfer pricing officer, so whether any variation is proposed by the transfer pricing officer or not, the assessee will be an eligible assessee, and the reason for giving this argument was that the revenue was pleading that when there is word income, the loss is also taken in that word income. Similarly, for variation, even the no variation should be included in that. When the court heard the matter, the court said that the contention of the department on this aspect was contrary to the statutory provisions because clearly there was no requirement to pass the draft assessment order, but the final assessment order has been passed by first issuing the draft assessment order and then asking the objections of the assessee. So the whole assessment is bad in law because the substantive provisions of law has not been followed. Friends, this case is very important because the revenue comes out with a pleading that no prejudice has caused to the assessee by following one or the other provision. But if that provision is required, if that is not followed, and if some procedure is followed and that provision was not required or vice versa, that assessment proceeding should be quashed according to this case. Friends, this case is very important. At the end of this video, once again, I am repeating the name of the case. The name of the case is Classic Legends Private Limited versus Assessment Unit and others, and this case is reported in 484 ITR at page number 550, and the date of the judgment is 9th September 2025. Thank you, friends.